Excellent. Okay. So this is just a quick guide on what the EU settlement scheme is. And it says here, as you can see on the slide, that it's basically the scheme that the Home Office have put in place so that EU nationals and their family members can get status before we leave the EU. And it's meant to be a simplified process, and it is in a lot of ways, but there's also a lot of issues. So we'll try and go through all of that. But this is a bit of a rundown on what we will do. So the first two bullet points here are the key ones. Is how to identify an EU settlement case so that you can kind of refer them on to organisations like ours, and sort of knowing the key requirements and some practical tips on how to get that kind of evidence together. And then these last two bullet points are kind of a little bit of extra information. This is a little bit, I've beefed this up a little bit since the last presentation because there's been a recent update from the Home Office, so there'll be some new detail that we can go through, but yeah, not that much has changed really. And then there'll be a chance for questions at the end. If you've got any questions as we're going along, you can just type them into the chat function, and then if I see them as I'm going along, I'll try to answer them, but I'll probably just leave them to the end, and then we can just deal with questions at the end. Yeah, so first section is just identifying who can apply and what an EU settlement case will look like. So it's basically for EU nationals. So any country which you would consider to be part of Europe, they can apply under the scheme. That includes countries that aren't actually in part of the EU. So, like Iceland and Norway and Switzerland, they can still apply under the EU settlement scheme in the UK. And Irish citizens, even though they have this kind of special status in the UK, where they're automatically deemed to have indefinite status, they don't need to apply for anything. They can still apply under the scheme if they want to. And on top of the EU nationals, their family members can apply. So you've got the classics would be, partners, married partners, civil partners, and those who've been living as married partners for, I think it's over 2 years, can apply, but they can be quite complicated applications. And then there's obviously children is a classic one, but then there's the kind of more less straightforward ones. So you've got dependent relatives in the ascending line, like grandparents, and then just any dependent relative. Generally, you would need to have already obtained any residence permit under the old system of applying, like as an EU, under the EU regulations, if you want to apply under the settlement scheme, and you still do have time to do that if you want to, but obviously we are running out of time, but we will get onto that in a little more detail. And then on top of that, you've got some slightly more complicated ones, which might not initially seem like they qualify under the EU settlement scheme, because they deal with family members of like British citizens or people who had a connection with an EU national that no longer exists. So there's some classic ones here, which are like, divorced couples. There's some specific requirements where if you're a non-EU national, but you were married to an EU national and you've now divorced, you can still apply under the scheme. Similarly, if the relationship's broken down due to domestic violence, or if you had that connection with an EU national and they've now passed away, they are more complicated applications. So if you come across any of these, it's worth just referring them to an organisation like ours. But yeah, the key thing to look at for is that connection to an EU national. But then on top of that, there's these British citizen applications. So even if it's not strictly an EU national in the UK and it's someone British, the most common one would probably be these ones where it's a single parent or a couple who are the parent of a British child, but the parent or parents don't have status of their own. They can apply under what's called this kind of Zambrano rule, but they're quite difficult applications. So you would definitely need to refer them to a legal professional. And like I said, yeah, you're looking out for some sort of EU national or a British citizen for someone to be able to apply under the scheme. So typically it'll be an EU national, but if you think there's a non-EU EU national parent of a British child, you might still want to refer them because they could qualify. And then it's just worth asking to make sure maybe there was a connection. So you could, if someone is divorced, you can ask if their former partner was an EU national and that sort of thing. It's hard to explain all these specific definitions in such a short time, but if you want to try and read them, you can check out this definitions section of the Home Office's immigration rules. It's really terribly written and formatted, so it's all just in one big block of text, but it is all there if you fancy checking it out. Yeah, another thing to look for is someone who's got a previous EU residence permit. So this was the old style application process where you'd be given kind of a biometric card proving that you were, say, like a family member of an EU national, or you were an EU national yourself. If someone's already got one of these cards, it makes it very easy for them to apply under the EU settlement scheme. And it'll say something like residence permit on it. So it's worth asking about that. And if someone's got a permanent residence card, they definitely still need to apply under the EU settlement scheme. So yeah, it's worth asking someone if they've got that. But if they have got a permanent residence card, their application becomes extremely, like basically 5 minutes to do it on the online application process. Yep. And so just briefly, the two types of status you can get are either settled status or pre-settled status. So if you've been in the UK for 5 continuous years, you don't have to have been working or self-sufficient for those 5 years. You just have to have been living, like resident in the UK. If you can prove that 5 continuous years or more, then you get settled status, which is permanent right to reside. And you don't have to make any further applications. It doesn't, like it says here, it doesn't have to be the 5 years leading up to the application you do. It can be any period of 5 years. And then the other one is pre-settled status. And all you need to prove for this is that you've been resident in the UK for like the last 6 months, at least. Well, not even that, within the last 6 months. So, that all that you're proving there is that you're more than just visiting the UK. So if say you're in a hotel and you're on a tourist, you're doing touristy type things, it might be hard to prove you're a resident in the UK, even if you're an EU national. But if you've got a bank account, you've got an address and that sort of thing, even if you've been here for just a month, you can prove residence for pre-settled status, and that'll give you 5 years leave to remain, with the opportunity to then convert that to settled status once you've lived in the UK for 5 years continuously. Okay, so this is just how to probably how to prepare people for an application. But I guess for that you also need to know the basic legal requirements. So we'll go through both of them. The key requirements are these top 3. So you have to prove your identity, and then prove your residence, Because for pre-settled or settled, you need to prove either 5 years or some kind of residence in the UK. And then the last one is called suitability, but that is essentially just checking someone's criminal history. Most of the time, people will have their ID card or a passport, and they won't have any criminal convictions. So it's literally just proving their residence in the UK, and that's all you need to successfully apply under the settlement scheme. And this is quite a big improvement on the old style application process, where you had to prove, an EU national had to prove they were kind of economically active to get any status. So they had to prove they were working. Sometimes had to prove their income was above a certain level. Or if they weren't working, they had to prove they were self-sufficient or a student. And on top of that, if you were either of those two categories, you had to have this comprehensive sickness insurance. And if you didn't have these, you could, under these kind of laws, still be seen as unlawfully resident in the UK. Whereas now it's literally just you prove your nationality, prove your identity, and prove you're actually living in the UK, and that's all you need. And the application's free, which is quite a big bonus. Yeah, so identity is the first one. It's quite strict, the types of documents you can use to prove this. So it's a passport and it has to be valid, and so it can't be an expired passport or a national ID card, because lots of countries have them, like Portugal or Romania. If you've previously had a biometric residence card or EU residence permit, you can use them as your proof of ID. But I'm pretty sure they still have to be valid, so they have to still be in date. And yeah, if you've got one of these documents, you can do the application via the online application process. If you don't, you have to order a paper application form, and we'll get to that. So yeah, some of the common issues are, yeah, expired documents won't be accepted, and there's quite a lot of vulnerable applicants, like victims of trafficking, domestic abuse victims, you know, who might have lost their ID document and don't have the means to get a new one, or you know, it might be, you know, for a domestic abuse victim, they might have left their passport in the home they fled and don't have a means of getting it. And yeah, so I mean, I feel like this strict ID requirement does tend to disadvantage the more vulnerable applicants, but there are other routes to apply. So yeah, if you have an alternative ID document, like an expired passport, you can use that to apply if you can meet this requirement. So due to compelling circumstances, like practical or compassionate reasons, you can't get a replacement valid ID and you have to use your expired one, or whatever you've got. Sometimes it won't even be an expired passport, it'll be some other Home Office ID card that they've been given or something. And we found the Home Office have a really differing, you know, varied approach with this. So sometimes we can call them up and explain a client's circumstances over a minute or two, and they'll just send us a paper application form out, and that's it. Other times they'll really battle with us and ask for all sorts of evidence to prove why there are these practical or compassionate reasons why they need to produce alternative ID. And I found that if you need to make these calls to the Home Office, it's worth just calling up on another day, because you might get a more lenient person at the end of the phone if you just try another time. So yeah, you need to get a paper application form if you're using alternative ID. And that just requires a call to this Home Office Resolution Centre. And they are actually quite, compared to a lot of Home Office departments, they are quite helpful. But yeah, like I said, you might need to call a third time to get someone who is particularly helpful. And they'll just post out this paper form with the client's name and kind of reference number on it, so you can't like make a copy and reproduce it for other applicants. Yeah, and if you are making referrals to us or to other organisations, if you are able to get these paper forms on an applicant's behalf, it just really speeds up the process. So if that's something you can do, that would be excellent. Okay, so the residence requirement is the main one, really. This is usually the main hurdle that applicants have to get over. Yeah, when you do the online application, they do take national insurance numbers and they just check your records. So if someone's worked full time for 5 years or more, the theory is this should just automatically say they're eligible for settled status. We found in practice it doesn't always work that reliably. Like we've had clients who have been working for that length of time and they haven't been sort of caught by this check, but it has worked a few times as well. So it is a good thing to have. But again, this disadvantages more vulnerable applicants who, you know, victims of trafficking who might not have been working through any like formal means. They won't be able to benefit from this process. This is hopefully quite helpful if you're referring cases to us, because this column on the left is what we really are after for proof of residence. So it's these kind of records that show annual activity rather than just a month's activity to prove someone's long-term residence in the UK. So annual bank statements, I think you often get them at the end of a year, or P60s and P45s. If you can get hold of someone's medical records, that can often be really useful. And then, you know, and then you go across these columns and it's less and less useful evidence, but still good. If the only option is to get someone's like full pile of monthly bank statements from the bank, then that is still going to be good enough. But there's a 10 document upload limit on the online Home Office application. So you have to, and there's a kind of file size limit as well of 6 megabytes. So you have to get pretty creative if there's a whole lot of evidence. We found that we have to just use this software that compresses PDFs, but it can be done. Okay. Yeah, so like I said, 5 years gets you settled status, but you don't need to show, for each year of that 5 years, you don't need to show like every single month residence. If you can prove 6 months residence within, say, 2016, so if you had, say, six monthly bank statements from that year, that proves residence for 2016. And for pre-settled status, it's any evidence of residence within the last 6 months. So you don't need to show the whole 6 months. You just need to show like residence. So obviously the more you can prove for that 6 months, the better. But say if you've got someone's latest bank statement proving kind of regular bank activity in the UK, showing a UK address, that'll be enough. And then the children can apply for settled status if their parent has settled status. And the children can get settled status without having accrued that 5 years continuous residence. So say if a child has joined a little bit later than the parent, or it might be a child that was born in the UK and is only like 3 years old, they can kind of apply to attach to a parent's settled status, like indefinite status, without having to have the full 5 years. So the next requirement is this suitability one, which is criminality. There's a few kind of involved areas on these slides, which we won't need to go into, but you can kind of read through them later. But the main thing is that the Home Office will check, even though they're asking us to disclose criminality, they will check against their own databases anyway. So it's very important that if an applicant has a criminal record, that they are upfront about it, because you can be refused for being for giving misleading information, sort of being dishonest. So it generally has to be quite serious criminality that will lead to a refusal, but we'll go through it. An application will definitely be refused if someone is subject to a deportation order or an exclusion order. So if you find someone who's facing deportation proceedings, it's not worth trying the EU settlement application. You need to find them a lawyer who can deal with the deportation first. And yeah, like I said here, an application can be refused or may be refused due to false or misleading information or making false representations. So that's quite important. The point there is that it's more beneficial for a client to disclose maybe like minor criminality than it is for them to try and hide it, because they're more likely to be refused for hiding a minor offence than they are for disclosing it. And this last point, proportionality, this is a really key point for cases where there is a criminal record. And that's just a balance that the Home Office is striking, where with their need to exercise immigration control to people who have committed criminal offences. So that kind of public interest in removing criminals from the country versus that person's kind of ties and how long they've been in the country. So if they've got family here, if they've been here for like 2 decades or something like that, it's going to be a lot harder for the Home Office to justify removing them based on criminality, because they're so embedded in the country, and it would interfere with their human rights quite drastically. Whereas if someone's been here for a year and their criminal offence is fairly serious, that proportionality is more likely to sort of balance in favour of removing them. At the moment, while we're still in the transitional period, which is this kind of period up until the end of this year, where all the EU regulations and law still applies, the law is quite lenient on people who've committed criminal offences. This bit in bold at the bottom is the key phrase. So people should only be refused status based on like serious grounds of public policy or security. And if they've been here for more than 10 years, that becomes imperative grounds of public policy or security. So that's a really high threshold. It has to be pretty serious. And this is a kind of a bit of a rough guide, but again, it all depends on that kind of balancing act, like how long someone's lived in the UK, with family ties and things like that. This is kind of a little bit of a guide of where people might struggle to succeed with an EU settlement application. So imprisonment within the last 5 years. Well, I'll let you read them in your own time, but that's the kind of list. But that's by no means a kind of hard and fast rule for people, because it all depends on their circumstances and like how long they've been in the country, basically. Yeah, as I said, it's crucial to declare criminal records. So again, one thing, if you're referring cases to us, one thing that can be helpful is to get their criminal record in advance. And this link is a good way of getting that, because a lot of people might not be 100% sure exactly what their criminal record is and dates and things like that. Yeah, that's basically just repeating what I said earlier. This is just a little add-on. Family members, dependent family members, don't need to apply with a full application for themselves if there's a kind of main applicant they can attach to. So this mainly applies with children. If a child's parent has already applied for settled status, whether they've got a decision or not, you can do a kind of much more streamlined application for a child, where you just kind of copy in the parent's application reference number, and it kind of attaches to the parents. And so this is where you'd get a child who, say if they've been in the UK for 3 years, but the parent qualifies for settled status, the child will just get settled status. Okay. So yeah, like I said, it's an online application form. There's this quite useful app, but it doesn't always work very well. And I think I saw one of the questions pop up is about it was about struggling to scan people's ID documents. But yeah, there's this app which scans people's IDs, which means you don't have to post it to the Home Office at the end of the application. And this can be really useful, but I find it doesn't always work that well. But because we're all working from home at our organisation, we can't do this scanning at all. So it is really helpful if we've got, you know, the council or other support organisations who have that access to the applicant, who can maybe scan the document for them. But generally, we've been getting applicants to just post their ID document, because we found that's just a little bit easier than trying to get people to fiddle around with the app. Okay, so this is where we've got some new information about the deadline. So we've got two deadlines basically. There's the transition period, which is ends on the 31st of December this year, and that is where, like, theoretically EU regulations and EU law doesn't apply to the UK anymore. But then after that, there's this kind of grace period where you've got until the 30th of June. And Euss has just released some new information about how this grace period will work. So I'll hopefully be able to explain that to people. Yeah, what I should say is that 30th of June deadline, final deadline at the moment. So if you're an EU national and you've yet to apply by that date, then you are deemed unlawfully resident in the UK, and you could face really harsh measures against you, even removal. And that applies to people who have permanent residence as well. So that's a really crucial point. Like, people with permanent residence cards will understandably have thought they had an indefinite right to stay in the UK. But because that derives from an EU, sorry, I think someone's got their mic on. So you could just mute this. I'm not sure who it is. That would be great. Anyway, if you've got permanent residence, it's still, that's derives from EU law. So that will expire on the 30th of June 2021. So you need to convert that to EU settled status. So you could have someone who's permanent resident, been here for decades, and they could still face, you know, being removed from the country and facing very harsh measures against them because they didn't convert it using the settlement scheme. Okay. So there's the transition period. Yeah, I mean, up until the 31st of December, everyone's rights basically stay the same. If you're an EU national, you're allowed to work, claim benefits, use the NHS, and all of that. After this date, you still will be able to reside, but your status will become a lot more shaky if you're not currently working or self-sufficient, which is kind of the requirements from the old EU system. The Home Office has said that the regulations kind of apply as they used to, even though in law they're saying they don't apply. But I'll try to make sense of that in a second. So this Home Office memo, that was recently sent, that was quite worrying, says it's all about people who are lawfully resident in the UK. So that phrase lawfully resident is kind of referring back to that old style requirement where you had to be economically active to have lawful status as an EU national. Just being an EU national and living in the UK doesn't give you lawful status. You have to be working or studying or self-sufficient. And so after this 31st deadline, and if you're not one of those people, you're deemed unlawfully resident. It doesn't mean you can't apply. You're still eligible to apply under the settlement scheme, but it does make your status a bit more precarious. I think it's extremely unlikely the Home Office would try to remove anyone or take action against anyone while you're still in that grace period. But it is a little bit uncertain for people. So there was a lot of pressure being put on the Home Office to change this kind of definition of lawfully resident, and just to say that people had a right to stay because we're in this grace period, but they've refused to do that. Yeah, so the Home Office lately have confirmed that even after this transition period ends, you can still apply for the old style residence permits, which is quite a good announcement, because that applies to people who, there's a few applications where you have to have this old style residence permit before you can apply under the settlement scheme. For example, if you're a long-term partner living as a married couple, but you're not legally married, you can't just apply under the settlement scheme. You have to first apply for a residence permit and then apply under the scheme. But this is saying that in this grace period, you're still allowed to apply for those old style residence permits. And that kind of gives you a bit more leeway in the future. And yeah, like I said, this kind of unlawfully resident definition hasn't been changed, unfortunately. But I think in practical terms, it shouldn't really affect people too much. You'll still be able to apply under the scheme. But I think the reason the Home Office aren't changing it is because they're saying you need to apply under the scheme. Like that's what you have to do to avoid having problems. So there's a little bit more information from these recent announcements. So after this transition period ends on the 31st of December, family members can still apply from outside the UK. So before this recent announcement, we weren't sure what people's rights were exactly. If they were a family member of an EU national living in the UK, but they kind of wanted to apply after this transition period ends. What we know now is that if you're an EU national living outside the UK, you can do an EU settlement application to join an EU national in the UK, but you can do that application from outside the UK, which is good. And similarly, you can do that if you're a non-EU national joining an EU national even after the 31st of December. So you can, if you haven't already got a residence permit, you have to apply for one of these old style permits first from outside the UK. But then once you're in the UK, you can apply to the settlement scheme within 3 months of arrival. And that's interesting because if, say, you arrived in the UK in May 2021, you'd still be given 3 months. So that would take you beyond that 30th of June 2021 deadline, but that's kind of an exception for those people. And after, this is the crucial point really, this is the key deadline. After the 30th of June, if an EU national hasn't applied, they are deemed an undocumented overstayer, basically. And they would face all those hostile measures that have been directed towards kind of non-EU nationals previously. So that's, struggling to find accommodation, landlords won't rent you, no employment, no access to benefits and all that stuff. And what would apply is, in its place, is this kind of new immigration system. But the Home Office hasn't really released any details on what that would be. But I think it's likely to resemble applications for non-EU nationals that is already in place. So I think this next slide, I can kind of predict what the new immigration system will look like after June 2021. So you'd have, instead of having no fee, you'd have massive application fees. So the current fee for a further leave to remain application is over £1,000. Plus you have to pay for any potential health like NHSK get in advance, which has gone up to £624 for each year you're in the UK as of October this year. So the general period people apply for these immigration applications is 2.5 years, and so with an application fee of £1,033 plus the immigration health surcharge, that's just over £2,500. So compared to a free application which gets you indefinite status, you can see what it's just a chasm in sort of quality, basically. Sorry, I'm just admitting someone. And then you have to reapply every 2.5 years until you've accrued 10 years continuous residence in the UK, at which point you're able to apply for indefinite leave to remain. And each application will cost that £2,500 or more. And then the indefinite leave to remain application will cost similar. So it's hugely expensive. And you almost definitely need a lawyer for it as well. So it's really concerning for EU nationals if they have missed the deadline. There is another slightly positive thing that's come out of the recent Home Office announcements is that there is scope for people to submit late applications. And I think where this will really help is for people who have had to apply for one of those old style permits before they can apply under the scheme, because those applications take a really long time. And so that might take people past the deadline. And so, yeah, the requirement is that a late application has to have been made within a reasonable period from the deadline date. And you have to give, reasonable grounds, like a reasonable explanation why you missed the deadline. So say if you had to apply for a family permit before you could apply under the scheme, you'll be able to say, well, I was waiting for my decision on the family permit, which is why I've had to apply past the deadline. Or what I'm hoping as well is if people have been refused an application, but they're still eligible to apply, they might be able to submit an application straight after that refusal and say, well, look, my application was refused for this reason, but I've now corrected that. And that's, but it's after the deadline. So hopefully that's a positive thing, but we've got no guidance on what reasonable grounds or a reasonable period will mean. So we don't know if the Home Office will be interpreting that harshly or leniently yet. Right, I know I've been going on for a long time, so we'll try to wrap up quickly now. So this final section is just some of the main concerns about this settlement scheme. The main thing is digital status documents, but there's a few others which I'll kind of race through. So if you're an EU national and you've successfully applied under the scheme, you get this digital status document, which is this online sort of web page almost that you have to log in to access. You have to have your passport number and a mobile phone that you've used to set it all up to access it. And I mean, this is a problem for lots of reasons, but the key one is that it just doesn't look like a viable status document. So the only, like, if EU nationals need to rent or apply or use the NHS, they generally have to prove their immigration status. The main one is renting. So a landlord will get fined a huge amount of money for renting to someone without immigration status. And if someone's only got this kind of printout document, or this document they can only access on their phone or on a website, it's going to be hard to persuade some landlords who might not be particularly clued up on the EU settlement scheme. So people might disproportionately, like EU nationals might disproportionately face like trouble getting accommodation because of this. And also it can cause just practical problems, like people might be coming through border security and they might have run out of battery on their phone, or they might not have internet signal or something. It might be very difficult to show this kind of weird status document on your phone, And for like elderly EU nationals, it might be very difficult for them to even access it because they might not be particularly computer literate anyway. So this is another issue, is just appeals. You can appeal a refused EU settlement application, but it's difficult it'll be difficult for lots of people to meet the costs, and there won't be that many lawyers available who can do it under legal aid. So there'll be a lot of low-income applicants who might have a valid appeal, but they just can't submit that appeal or can't lodge that appeal because of the kind of restrictions on it and the lack of legal aid lawyers available to do it. And yeah, I mean, this is more practical issues, is just COVID obviously wasn't expected by anyone, but it has really delayed decisions. There's been a huge backlog, and the Home Office has seemed pretty inflexible on extending any of their deadlines. And we found that there's been really long delays for people, sometimes like over a year, for certain more complicated applications. And obviously that's just increases anxiety for people, especially as we approach the deadline, the final deadline to apply. And this is another key problem, which seems to be quite prevalent across the country, is that it seems that not enough EU nationals in the country are aware of the scheme. There's been lots of positive figures put out by the Home Office that millions have applied already, and that is great, but it seems that a lot of EU nationals just still aren't aware that they need to apply. There's this report of these migrant workers in the Fens, where about half of them were aware of the settlement scheme, and just over 40% of people who planned on staying in the UK long term out of that group said they were unaware of the settlement scheme, which means, you know, they're eligible to apply, but they don't know they need to. And then a big problem with it is just the fact that it's only on this, is almost entirely restricted to this online application process, which is all done in English. There's no different like language options to do it, and there's just thousands of EU nationals in the UK who don't speak English, and so they need someone to help them with the application. Otherwise, they just don't have access to their right to stay in the country. So this same report said that 75% of the people they interviewed needed an interpreter for the survey they did. And there's just a lack of interpreters available. And I just don't think that there'll be a huge proportion of people who don't get caught by the settlement scheme, who could have applied. And yeah, it's worrying. It's worrying that you know, once that deadline passes, that's it. So yeah, some positivity. We can help by submitting the complex cases. We have interpreters for the people who can't speak English. For really complex cases, we can open like legal aid files and do a full, like proper, running it like a proper legal case. We can appeal refusals potentially, but that's all down to whether we've got capacity to do so. And then we can offer this sort of advice and support to third parties, and we're always available to help out on what, you know, practical support for other people who can help people apply. So here's our contact information. We'll send these slides at the end, so you'll have our emails and phone numbers from there. And then this is just some useful links. This free movement one at the bottom. For a lot of the articles, you need to pay. You need to have membership for this website, but the more recent ones, you can still access them for free. And they have lots of really good updates on the EU settlement scheme. And with this recent update from the Home Office, they've got a couple of really useful articles on there, which should be accessible. And these are just some extra slides which we've added in recently. This isn't our law centre, but this is another organisation or sort of support contact that can be used. And it's just, I won't read it all out, but it's all there. You can check from the slides. So it's just another really useful service for not just for EU settlement cases, but for, I think, for other people as well. And that's it. So I'm sure you're bored of listening to me now for nearly a whole hour. It's not normally as long as that. So if anyone's got questions now, feel free to turn your mic on and ask, or just type a question in the chat. I think there was one already, so I'll just go to that first. Oh, there's more than one. Let's make sure I've got the first one. Yes, that one's from Lola. So the question is, I found that there's been an issue scanning with Portuguese ID cards using that app. I haven't had to try and scan any ID cards for a long time because, like I said, we're working from home. But from what I remember, the app was really temperamental, and I think the organisations who are still helping us, they still have loads of trouble with the app. We've kind of almost abandoned using it now because I do lots of applications with the same charities, and we've just found it runs a lot smoother if we just post people's ID to the Home Office and then wait for them to post it back. They tend to post it back within a couple of weeks anyway. So if the app is being a pain, if you're helping with these applications, I would just consider just posting the ID document instead. But it does work as well. It works for lots of ID cards and passports. So it is worth persevering if you can get it to work. Oh, that's a good question. The second one from Lola. If you're granted pre-settled status, do you have access to benefits? In theory, you can do, but this is where it gets a little bit complicated with that sort of tension between the old rights under the EU regulations and this new kind of grant of status. So with settled status, it's indefinite leave to remain, and you've got all the rights as a British citizen, basically. So you're allowed to access the benefits. But with pre-settled status, you kind of have to prove, I have to check the exact requirement because it's a little bit involved, but there's more to it. You have to prove particular requirements to gain access to benefits, and I think it derives from that those old EU requirements. But that's something I can check on and get back to you on. So another one from Silvana. Does someone need to wait for the 6 months to be up to apply for pre-settled status? So that one, you don't have to have been in the UK for 6 months to apply for pre-settled. You could have been in the country for like 2 weeks or maybe even less. The main requirement is you have to provide evidence of residence from like the last 6 months. So they say 6 months because a lot of people have been in the country for like 3 years. So they don't apply for, they're not eligible for settled status, but they have to show some sort of proof of residence from the last 6 months before they've applied. But if you've literally arrived in the UK like a month ago, all you have to do is prove you're resident in the UK. So that could just be your most recent bank statement, or a utility bill or something like that. You don't have to have proven 6 full months residence. And then there's another one. Is the biometric residence permit a mandatory prerequisite to pre-settled status? So that no, the answer to that is no. So you don't have to have had any status before applying for either settled status or pre-settled. There's an exception. There are exceptions to that depending on the kind of route you're going down. But if you're literally just an EU national living in the UK, you don't have to have had a previous residence permit to qualify. The main one that I can think of where you do have to have a previous residence permit or relevant document, as the Home Office call it, is for durable partners. So that means people who have lived as a married couple who aren't married. They have to have a residence permit on that basis before they can apply under the settlement scheme. And you have to do that. So the next question is, how do you apply for that relevant document? You have to basically do the old style, like EU application, which are these, some of them are like 80 pages application forms, and there's lots of evidential requirements as well. So it can be a real pain for people. But yeah, the encouraging thing is these recent updates from the Home Office seem to suggest that people will be eligible to apply after the deadline passes in June next year, if they've had to wait a really long time for that residence permit to be granted. And what I've been saying to people is I think you can apply for the residence permit and then immediately apply for the EU settlement scheme while you're waiting for the residence permit to be granted, just to show that you've put the settlement application in early enough. And then I think the Home Office will just wait to see if you're granted for the residence permit before they deal with the settlement scheme application. I hope that's clear. Yeah, and Angela's asked if we're sending out the slides. Yep, we'll be doing that. Because I know sometimes I just end up rambling and going into a lot of detail. And I think if it was new to me, I just would not take any of it in. So hopefully being able to go over the slides might be helpful. But I'm sorry if it's not. I'll wait a little while for any other questions if there are any. Just a couple of minutes, I suppose. I can see people are typing, so I will wait a little while longer. Well, that's a really good question from Lola. So yeah, it just says, will the Home Office ask for more evidence of residence, or will they just reject the application if they think there's not enough evidence? This is another area where I've noticed a big improvement in dealing with the Home Office. Oh, Lola's left, unfortunately, so she won't hear my answer, but hopefully it will still be recorded. And here she is. Just making sure she's back. Yeah, so to answer Lola's question, yeah, the Home Office have been a lot more cooperative in terms of the evidence requirements. So if the Home Office has previously, if they thought there wasn't enough residence evidence, they might just refuse before this EU settlement scheme came in. But they are quite cooperative with the settlement scheme. So generally they will ask for more. They'll send you an email saying there's some gaps here, you need to provide evidence for this. And they will give you a lot of leeway and a bit of time to find what you need. So yeah, it's much better than it was. But occasionally you do get some unreasonable requests and you have to kind of push back and say, I don't see why you need this. This isn't in the requirements. But generally, yeah, they're not too bad. The casework team for EU settlement. Sorry. Yeah, another good question from Rola. Yeah, so we come across these types of cases quite a lot. So like you said, a homeless person who's being supported. We get lots of victims of trafficking as well. And they might struggle to provide the necessary evidence. Again, the Home Office have been quite helpful, and they do cooperate with cases such as this. So a key one is the ID requirement. We get a lot of people who don't have ID, and they have to find a way to get alternative ID or find a way to get some sort of replacement. And it can make the application process a lot longer, but the Home Office generally will give you a paper application form and let you submit the ID that you have got for cases like this. And when you do that, you can provide lots of representations about why they're vulnerable and why they can't get the replacement ID they need. But you do need some kind of ID, so that there needs to be something. It could be like a birth certificate, or it could even be an old ID card the Home Office has given them. In terms of residence evidence, it can just be unfortunate for certain people. Someone might have been here for the last 10 years, but if they've been in a situation where they've been trafficked, or if they've been homeless and don't have any documents to their name, they just have to accept that they're going to get pre-settled status instead of settled. Because if they're living in the UK, if they're here, they can provide something from the last 6 months to prove it, but they might not be able to provide that full 5 years. So for a lot of these people, they unfortunately have to settle for pre-settled status if they can't produce enough residence evidence. Yeah, and that's another one. So we've used COVID as a legitimate reason why someone can't get replacement ID. I don't know if they would accept it like with going to an embassy in the UK. I think they might still expect people to do that. But we've had cases where the Home Office has been saying that clients need to go back to their country of origin. Like, we had one guy, a vulnerable guy, who was a failed asylum seeker from Albania and had been abused by his parents, and the Home Office had accepted that, but still said he needed to go back alone. He's only 19 years old, saying he had to go back alone to get his replacement ID in Albania and then apply under the settlement scheme from Albania. And thankfully they saw sense on that one, and we were able to persuade that he couldn't do that because of COVID and various other reasons. But yeah, COVID can definitely be used to say, like, there's compelling reasons why they can't get, valid ID, and they have to accept an expired ID card or something like that. I will let you finish typing, but I have got an answer to the pre-settled status benefits question as well, which I will answer in a second. Yeah, so again, so I'm just reading out the question. Yeah, does the embassy need to confirm that they can't provide ID, whether because of COVID or not, basically? This is often something the Home Office specifically asks for. If we're using alternative ID, they'll say, why can't you go to the embassy? Can you provide a letter from the embassy to say why they can't produce a replacement in time? So, for example, like the Romanian embassy, I think because so many people are trying to get replacement documents, are quite keen to provide letters to say this is how long it'll take, and it might take people past the deadline. And so you can get these embassy letters from a lot of embassies, but others are a bit more tricky to deal with. I don't know if an embassy would say because of COVID. I've not had one say that, but you probably could. And just going back to that, benefits question, because this does come up quite a lot. People with pre-settled status, this seems really contradictory to me, but people with pre-settled status have to prove that they are lawfully resident under the old style EU regulations in order to have access to benefits. But the kind of paradox of that is that being lawfully resident often goes hand in hand with being kind of economically secure. So to be lawfully resident, you have to be working, or you have to be self-sufficient. And if you are self-sufficient, then you're less likely to need access to benefits, or if you're working, you're less likely to need benefits. Whereas the people who are here, like unlawfully in the eyes of the Home Office, like not exercising their treaty rights by working or studying or being self-sufficient, they're the ones who need access to benefits, but they can't get them. So it's a bit of a cruel rule, that one. But if someone can get like a part-time job or some sort of work, then they should be able to get access to benefits. And I think, I'm not a benefits lawyer, but I think there are ways to kind of get these people access to benefits anyway, but it takes a little bit of sort of clever legal wrangling, I think, which is not my area of expertise, unfortunately. Well, I've answered more questions there than we usually get, so that's pretty good, especially as this is the one that's being recorded. Unless anyone's got any other questions, I think that's probably a good place to leave it. Oh, I can see a couple more people typing. And yeah, just to confirm, we will send out like a PDF of all these slides like now, basically. So you'll be able to check anything that might not have made sense. And also, I mean, we've got our emails on these slides as well. And part of the funding we get for our EU settlement work is giving advice to other organisations and councils. So like if you've got a question or you're not sure about something like the law, we're kind of obliged to give you advice and help with that. So yeah, make sure you do ask if you've got any questions, and we will be able to help. Cool. Thanks, guys. I will leave it there, I think. So just feel free to email me if you've got any questions. And thank you for your patience. That's quite a long session, that one. Cheers.